All right, it looks like we are admitting all of the folks who are joining this. So we're going to give it just another like 30, 40 seconds and let everybody online. All right, so we're going to go ahead and get started. My name is Travis Hall. I am a policy analyst with the National Telecommunication and Information Administration. And I would like to welcome and thank all of you for joining and participating in what we think is going to be a very interesting and important set of events. We're still having a few more folks joining, which of course is very exciting. So really quick, these listening sessions are going to be focused in on the intersection of privacy, equity, and civil rights. NTIA has long been engaged in questions surrounding privacy policy, including the 2012 Consumer Privacy Bill of Rights and the 2013 draft legislation, and of course the 2018 request for comment. Today's session within that area of privacy, equity, and civil rights is going to focus in on questions of the law. So civil rights laws, privacy laws, and other laws that are that could potentially help alleviate some of the harms and some of the risks in this space. We'll start off with an opening by our NTIA's Acting Assistant Secretary, Evelyn Romali, with keynotes by Assistant Attorney General Kristen Clarke, and recorded remarks by FTC Commissioner Rebecca Slaughter. This will be followed by a panel of privacy and civil rights experts that we're really excited about, and then a public listening session where we will be taking comments from you, the public, from interested stakeholders and individuals. Just a few really quick housekeeping rules or notes for participation. This event is going to be recorded. And we have Microsoft Teams accommodates up to 300 participants. We are going to be posting these events to our website as soon as possible following them. And live captioning is available through the Teams desktop, mobile, and web applications, but live captioning does need to be turned on by the individual participants. NTIA staff will be monitoring the live chat video and audio, and we will remove participants who attempt to disrupt the proceedings. So we will get into a little bit more of the house rules for public participation once we get to that section. With that, let me turn over to our Acting Assistant Secretary, Evelyn Romali. Thank you.
Thank you, Travis, and thanks to AAG Clarke, Commissioner Slaughter, our esteemed panelists, and everyone who has taken the time to virtually join us today. I would also like to thank the NTIA team who have worked hard to pull today's convening together. As our lives increasingly take place online, our communications, transactions, opportunities, and institutions are newly mediated by digital services. This transformation can fuel a more innovative, efficient, and democratic economy, but it can also replicate old inequities and reinforce discrimination towards vulnerable groups, including people of color, people with disabilities, LGBTQ people, low-income people, and others. This trend has been with us for a while now, but the COVID-19 pandemic rapidly accelerated it, both in terms of amazing and life-saving innovations that allowed many of us to rapidly adapt to socially distanced working conditions, but also through the replication of historical disparities. Today, we'll discuss some of these problems with a focus on the laws that can be applied to address them. We are past the point of privacy and civil rights conversations being siloed, as our privacy laws must grapple with potential disproportionate harms to marginalized communities by some data practices, and our civil rights laws must adapt to recognize the digital ecosystem. Again, I thank you for joining us this afternoon for this long overdue discussion. And with that, I will hand it back to Travis to introduce our first speakers. Thank you.
Great. Thank you so much, Evelyn. With this, I would like to introduce Assistant Attorney General Kristen Clarke from the Department of Justice, who heads up the Office of Civil Rights. Assistant Attorney General Clarke, please.
Thank you so much, Dr. Hall, and Acting Assistant Secretary Romilly for those opening remarks. I'm truly honored to be here today. We appreciate the leadership demonstrated by the National Telecommunications and Information Administration, or NTIA, in hosting these important listening sessions and bringing together subject matter experts across academia, think tanks, advocacy organizations, government, and industry with members of the public for these critical discussions on privacy, equity, and civil rights. As Assistant Attorney General for the Civil Rights Division, I have the great privilege of leading our federal civil rights enforcement efforts across the country. The Civil Rights Division works to uphold the civil and constitutional rights of all people in the United States, particularly some of the most vulnerable members of our society. I've focused my entire career on fighting for racial justice and civil rights. And I know that the civil rights and privacy implications of the use of artificial intelligence are high stake. In this incredibly important listening session, we're going to unpack these issues and learn more. I think the session could not be more timely or more urgent for communities of color and other vulnerable communities who have been subjected to historical and ongoing discrimination. I'm grateful for today's opportunity to join the NTIA to advance our shared mission of justice and equality as we turn to the subject at hand: discrimination and other harms to marginalized and historically excluded communities, stemming from the commercial collection and use of personal information. As we know, personal data originate from a multitude of sources, including public records, web browsing activity, emails, banking activity, social media, and more recently, app usage on smart devices. Consumer reporting agencies, data brokers, internet platforms, digital advertising companies, and other businesses are making millions of dollars compiling and selling consumers' digital profiles. We also know that much of this personal data is also being fed into specialized algorithms that are used to make critical decisions affecting many aspects of our daily lives. Algorithmic decision-making is increasingly influencing how employers hire, how banks decide who gets a loan, how police departments monitor individuals and communities, how courts determine risk, how government agencies make benefits determinations, and how businesses target advertisements to consumers. And as entities increasingly rely on algorithms to make decisions, their decisions become increasingly difficult to challenge because the process is so opaque. This lack of transparency and accountability raises serious concerns about inaccuracy and also opens the door to potential discrimination. At the Civil Rights Division, we are particularly concerned about how the use of algorithms may perpetuate past discriminatory practices by incorporating and then replicating or baking in historical patterns of inequality. I want to talk with you today about where we at the Civil Rights Division see issues that lie at the intersection of AI and civil rights issues, and how we are working to address it. Congress established the Civil Rights Division through the Civil Rights Act of 1957, focusing primarily on the need to enforce voting rights laws. 64 years later, the division has grown dramatically in both size and scope and has played a central role in many of the nation's most significant civil rights battles. In addition to continuing our critical work to protect the fundamental right to vote, our mission has expanded to embrace federal statutes prohibiting discrimination on the basis of race, color, sex, disability, religion, familial status, national origin, and citizenship status across the work of 11 sections. Through lawsuits, investigations, public education, regulation, policy coordination, technical support, and more, we strive to promote the core principles that animate our democracy: equal opportunity, racial justice, and fairness for all. The Civil Rights Division and the Justice Department as a whole leverage powerful tools to combat discrimination, including discrimination resulting from algorithmic bias. These laws include the Fair Housing Act, the Equal Credit Opportunity Act, Title VII of the Civil Rights Act, the Americans with Disabilities Act, Title VI of the Civil Rights Act, and a host of other federal statutes. Civil rights laws traditionally present two theories to combat discrimination: disparate treatment, which is intentional discrimination, and disparate impact, which deals with neutral practices that disproportionately and adversely affect protected groups. AI and data use issues that intersect with our civil rights work in numerous ways. For example, in the fair housing and fair lending context, we know that financial institutions collect and use large amounts of consumer data to make predictions and decisions in the context of underwriting, pricing, and loan requirements, as well as advertising for all types of loans, including home loans, car loans, and student loans. Academic studies and recent news reports tell us that purportedly neutral algorithms can end up amplifying or reinforcing unlawful biases that have long existed around race, home ownership, and access to credit in our country. We need to ensure that use of data and algorithmic modeling is more transparent so that we can address these problems and avoid discriminatory outcomes. AI and data privacy also affect hiring and employment. We're seeing reports of increased use of AI by employers to solicit job candidates and screen applicants. In addition, employers may be using predictive analytics to target job advertisements to shape the applicant pool in the first place. These tools can certainly expedite the hiring process, but whom an employer targets and which criteria it uses to weed out candidates must be analyzed to understand whether these decisions further discrimination, benefiting one class of people over another. The employment context provides a good example of the principle that AI is only as unbiased as the programmers writing the algorithm and the data they rely on. If a programmer inputs only resumes of people whom a particular company has previously hired, and the previous hiring team harbored biases and preferences, then the newly created algorithm inherits those biases and preferences in screening applicants. This is the problem of baking in discrimination that I mentioned earlier. AI technologies also have serious implications for the rights of people with disabilities. For example, some employers have utilized video interview and assessment tools that use facial and voice recognition software to analyze body language, tone, and other qualities to determine whether candidates exhibit preferred traits. If these tools are not implemented properly, they can limit access and discriminate against people whose disabilities affect their facial expressions or voice, such as people with deafness, blindness, or speech disorders. AI concerns also arise in the context of education. Algorithmic decision-making is already in wide use in our educational systems. For example, it can be helpful for employers to match students and mentors for support, like tutoring, but AI can also reproduce inequities through AI-driven approaches to admissions, student sorting, school discipline, and educational redlining. Furthermore, relying on historical data may affect student loans in much the same way as it may affect credit and housing, with some research suggesting that minority students are more likely to pay higher rates on their educational loans. Finally, the criminal justice system employs AI tools, including predictive policing, facial recognition software, and risk assessment tools. We must be vigilant to ensure that these tools do not operate in ways that violate civil rights laws. These are only some examples of how AI issues come up in the context of the Civil Rights Division's work. The division is committed to using the tools that we have to ensure that entities do not discriminate through their use of AI systems. To address these significant issues and challenges and to evaluate the potential impact of AI on civil rights, equal opportunity, and civil liberties, I am proud that the Civil Rights Division is taking a holistic approach and marshaling its resources in 4 main areas: enforcement, education, outreach, and interagency coordination and policy. First, let me talk about our enforcement efforts. We are undertaking a number of steps to strengthen our capacity for enforcement in the AI arena. We are analyzing developments in case law pertaining to AI and civil rights. We're also working to identify fact patterns that could arise under our enforcement authorities, including in employment, housing, credit, public benefits, education, disability, voting rights, and the criminal justice system. Finally, we're identifying specific AI civil rights enforcement opportunities, including options for submitting statements of interest, impending litigation. Let me say a word about education and outreach. We recognize that the intersection of AI and civil rights features a rapidly evolving policy and legislative landscape, and that it is critically important to engage with AI experts and think tanks, academic and research institutes, and advocacy organizations. And for that reason, the division launched a speaker series featuring stakeholders and experts on algorithmic tools and their ramifications for civil rights. Next, there's interagency coordination. To ensure that a civil rights lens is applied to federal programs and activities across the board involving AI, the Civil Rights Division is currently connecting with a number of efforts across multiple federal agencies and organizations working to develop AI ethical frameworks and guidelines. Through this process, we have heard from a number of thought leaders across the federal government on AI issues that intersect with civil rights, civil liberties, and equal opportunity. Finally, there's policies. And right now we are studying whether policy or legislative solutions may also offer effective approaches for addressing AI's potential for discrimination. We're also reviewing whether guidance on algorithmic fairness and the use of AI may be necessary and effective. This multi-track approach is necessary because while the division's enforcement efforts can remedy discrimination with respect to specific facts or issues at play in a particular investigation or case, to fully and more meaningfully address discrimination for all protected classes, early intervention in the design and development process is key. We know that many of those who are participating in this listening session represent organizations that have long been on the front lines combating discrimination. You have mounted resource-intensive litigation to fight discrimination. You have driven legislative and policy changes at every level of government, and you've launched public outreach campaigns that are critical to raising awareness. You've also continued to provide important voices supporting investment in pilot programs regarding non-discrimination. Thank you for your work. As we consider the civil rights implications of the use of AI, our thinking is very much influenced and informed by your input and feedback. So again, thank you for your efforts, and we look forward to learning much from all of you over the next several days and beyond as we work together to advance justice and equality in AI. Thanks so much for having me.
Thank you so much, Assistant Attorney General Clarke. That was extraordinarily informative and very helpful to situate both our conversation as well as the work that you and your team are currently pursuing. With that, we are now going to have recorded remarks from the Federal Trade Commission's Commissioner Rebecca Slaughter, who unfortunately was not able to join us live, but was able to provide us with recorded remarks. I will note, even though we are now almost 2 years into the pandemic, we're still, of course, figuring out some of these technological stuff. The video might be a little bit jerky, but we've tested it earlier and the audio works just fine. So thank you again, and thanks to the FTC for making Commissioner Slaughter available in this format. So Ryan, if you could go ahead and get that video started for us, that would be great.
Good afternoon, everyone. I'm Commissioner Rebecca Kelly Slaughter from the Federal Trade Commission. It's my pleasure to be able to address you all at the start of the NTIA's listening sessions on privacy and civil rights. I'd like to thank Assistant Attorney General Kristen Clarke for her remarks. The country is so fortunate to have her leading on civil rights and economic justice issues at the Department of Justice. Thanks as well to everyone at the NTIA for putting this event together. Addressing the systemic harms of the data economy, especially those related to civil rights, is going to require coordination across agencies and sustained public participation. I'm excited to hear from the scholars and advocates speaking over the next few days. Your work is integral to advancing policymakers' understanding of these issues, and your persistent advocacy helps ensure that we take bold action, advancing the cause of fairness, civil rights, and justice in every corner of our economy. I'm particularly excited that the organizers of this listening session have recognized from the outset that unfair or invasive data practices like digital redlining, over-surveillance, and other harms to historically marginalized groups extend beyond a limited understanding of privacy violations. These harms, which I think of as data abuses, often stem from the indiscriminate collection of personal data in order to fuel pervasive commercial surveillance in our economy. The framing of these listening sessions has it right, and I think it is reflective of an evolution in how the government is approaching data and technology issues across agencies. I can't emphasize enough how glad I am to see us all talking about these issues this way. The Department of Commerce and the White House have recently announced some artificial intelligence initiatives in an effort to guide the safe use of these tools in the economy. We're seeing the application of this technology in fields from healthcare to criminal justice, employment, credit, and housing, all sectors where historically marginalized communities have been shut out of full and equal access to opportunities and services. Some of the application of these technologies holds promise. It can help distribute opportunities more broadly, resources more efficiently, and benefits more effectively. But technological tools are not necessarily free of the weaknesses that plague their human designers, and they can be used to perpetuate and exacerbate discrimination and injustice. Agencies across the government need to take action to address these issues within their spheres of competence. I'd like to unpack some of my own thinking about the harms of algorithmic decision-making and artificial intelligence that exist at the intersection of privacy and civil rights. Talk about the tools and legal authorities we have at the Federal Trade Commission to address these harms, and how the FTC can play a role with rulemaking. I've been thinking about algorithmic harms in a few different ways. Poorly designed algorithms facilitate discriminatory harms through faulty inputs, faulty conclusions, and a failure to audit or test those algorithms for discriminatory output. But not all harms stem from design. Algorithms can facilitate proxy discrimination, enable surveillance capitalism, and inhibit competition in markets. Failure to closely scrutinize the impact of data-driven decision-making tools can further discriminatory outcomes. Figuring out how to map the FTC's authority onto these new technologies in order to effectively and proactively address these harms is a challenge. But fortunately, we have at our disposal our general authority under the FTC Act, sector-specific rules and statutes, such as the Fair Credit Reporting Act and the Equal Credit Opportunity Act, and our Section 18 rulemaking authority. Most of the enforcement activity conducted by the FTC is brought under the general authority provided to the Commission by Section 5 of the FTC Act, which prohibits unfair or deceptive acts or practices. The Act is more than a century old, and since its passage, the agency has been able to apply the statute's general language to meet new enforcement challenges. That same approach urgently needs to be applied to the harms generated by the data-driven economy. We have our Section 5 deception authority, which can be used in connection with algorithmic harms where the marketers of certain products or services represent they can use machine learning technology in unsubstantiated ways. I believe the FTC has an opportunity here to call out algorithmic snake oil, especially in areas like facial or affect recognition, where it's likely these products just cannot deliver on their promises and create huge society-wide harm when their hype is taken at face value. We can also use our unfairness authority to target algorithmic injustice. The unfairness prong of the FTC Act prohibits conduct that causes or is likely to cause substantial injury to consumers, where that injury is not reasonably avoidable by consumers and not outweighed by countervailing benefits to consumers or to competition. I believe discriminatory harms fall neatly within our unfairness authority. Surreptitious location tracking could give rise to this type of claim. Or we could use unfairness where an algorithm is used to exclude a consumer from a benefit or an opportunity based on her actual or perceived status in a protected class. Our unfairness authority goes beyond traditional civil rights claims as well. It gives us the opportunity to examine practices like facial recognition and other kinds of increasingly unavoidable biometric data collection, which may lead to discriminatory outcomes. I also believe we should look towards more creative enforcement of our FCRA and ECOA authority. For example, ECOA prohibits credit discrimination on the basis of race, color, religion, national origin, sex, marital status, age, or because you get public assistance. Everyone who participates in the decision to grant credit or in setting the terms of that credit, including real estate brokers who arrange financing, must comply with ECOA. If lenders are using proxies to determine groups of consumers to target for high interest credit, and such proxies overlap with protected classes, the FTC should investigate and, if appropriate, pursue ECOA violations. An even bolder approach that I would like to see the FTC take is to incentivize creditors to make use of the ECOA exception that permits collection of demographic information to test algorithmic outcomes. ECOA permits and the FTC should encourage non-mortgage creditors to collect demographic data on most borrowers as long as they use it in order to reduce disparities and train AI and other algorithmic systems to reduce them. Vanishingly few creditors take advantage of this exception, thinking it's just much easier to never ask about race or gender. But this kind of self-testing has to be part of any effort at ensuring that algorithms do not create discriminatory outcomes. Finally, I believe it's past time for the FTC to begin a Section 18 rulemaking process on data abuses. Among other benefits, this process can have a clarifying effect for the congressional debate as well. Participating in the rulemaking process means businesses, advocates, consumers, workers, researchers, and other interested parties will all have the opportunity to make their opinions known, out in the open and with specificity in the public record. An open record can provide substantiation of the types of consumer protection and competition harms people are experiencing in digital markets and illuminate how we can act decisively to stamp out these abuses. If and when the FTC opens that rulemaking record, I hope we'll see the kind of broad participation from the experts we're about to hear from at the NTIA today about how we can best address these harms. The era of deploy and hope for the best, or move fast and break things, has to be over. We're living with the consequences of an unregulated tech sector. I hope the next generation of technology is deployed with a critical eye towards its potential harmful effects, so we can all reap the benefits of advanced algorithmic decision-making together. Thank you all for your time.
And even though she can't hear me, thank you so much, Commissioner Slaughter, and thanks to your team for making this possible. With that, I'd like to welcome our panelist and our moderator for today's panel. These panels are intended to help to lay a baseline of facts for the public listening session conversation, and also to provide some additional framing, and of course to rely on the expertise of these really awesome presenters. And with that, I'd love to turn it over to my colleague, the Chief of Staff for our Office of General Counsel, to Lauren. So Lauren, and the others on the panel, if you wouldn't mind going ahead and coming online. Excellent.
Thanks, Travis. I'm really looking forward to the conversation this afternoon. Assistant Attorney General Clarke and Commissioner Slaughter's remarks provide us with a great introduction for our panel discussion, during which we'll explore the application of existing privacy and civil rights laws to commercial flows of personal information and where there may be gaps in those laws. I want to start by welcoming and introducing our panelists. I think it's up to each of us to unmute and put ourselves on video. That's what I had to do. I think we each have to do it for ourselves. With us today are David Brody, who is Senior Counsel and Senior Fellow for Privacy and Technology from the Lawyers Committee for Civil Rights Under the Law. Is David with us? Can we see him? Great.
Yes.
We also have Bertram Lee Jr., who is Counsel for Media and Technology with the Leadership Conference on Civil and Human Rights. We have Aaron Konopasky, who is a Senior Attorney Advisor in the Office of Legal Counsel at the U.S. Equal Employment Opportunity Commission. We have, welcome Aaron. We have Lydia X.Z. Brown, who is Policy Counsel for the Privacy and Data Project at the Center for Democracy and Technology. And we also have Michelle Gilman, who is Venable Professor of Law and Associate Dean for Faculty Research and Development at the University of Baltimore School of Law. Thank you all so much for being here today. I'm going to ask each of you to spend about 5 minutes introducing yourself in a bit more detail than I have and sharing your thoughts on key issues related to the application of existing civil rights and privacy laws to data practices. Then I'll ask a few questions, and if we have time, I'd like to ask a question or two from our audience members. So audience, please feel free to put a question into the chat. And with that, let's get started. David, will you start us off, please?
Sure. Hi, thank you for having me, and thank you to NTIA for putting this together. I'm David Brody. I lead the Digital Justice Initiative at the Lawyers Committee for Civil Rights Under Law, a national racial justice organization started at the request of President Kennedy in 1963. So to begin, why is this a civil rights issue? Privacy rights have always been about civil rights. We care about privacy because we do not want information about who we are to be used against us in unfair ways. That's the essence of civil rights. The term privacy, however, is a bit inapt and misleading. It implies we are focused on the secrets of an individual, whereas what we truly care about are the societal impacts from the use of mundane personal information, like redlining. Redlining was and is the exploitation of personal data to discriminate. As Chief Judge Gregory of the Fourth Circuit recently observed, quote, "Many measures of resource distribution and public well-being now track the same geographic pattern. Investment in construction, urban blight, real estate sales, household loans, small business lending, public school quality, access to transportation, access to banking, access to fresh food, life expectancy, asthma rates, lead paint exposure rates, diabetes rates, heart disease rates, and the list goes on," end quote. We cannot repeat in this new millennium the mistakes and inequities of the previous millennium. The history and evolution of civil rights law has always involved adding new and complementary authorities and agencies to augment existing laws. Some of the first federal civil rights laws were passed in Reconstruction. Section 1981, which addresses commerce and contracts, and Section 1982, which addresses property and housing. In theory, these cover almost all economic issues, but in practice, they fell short. Despite its broad scope, Section 1981 did not prevent employment discrimination or the separate but equal doctrine that allowed services to be segregated so long as they were technically equal. Despite its broad scope, Section 1982 did not prevent the rise of redlining and housing discrimination. In the 20th century, Congress saw these failures and added on with new authorities. In the Communications Act of 1934, the FCC was explicitly mandated to prevent discrimination in telecommunications in Section 151, and this was implemented through Sections 201 and 202. This is despite the fact that Section 1981 can cover some forms of telecom discrimination. Congress still thought a more nuanced statute and rulemaking authority was necessary. In the Civil Rights Act of 1964, Congress created public accommodations protections in Title II to end segregation and employment discrimination protections in Title VII, even though Section 1981 addressed these issues partially. In the Fair Housing Act, Fair Credit Reporting Act, and Equal Credit Opportunity Act, Congress addressed redlining as well as housing and lending discrimination, even though Section 1982 already applied to these areas, and even though the FTC could and did use its UDAP authority to go after housing discrimination. In the Dodd-Frank Act, Congress created CFPB despite existing overlapping authorities at other agencies. And the FTC has often had overlapping authority to enforce and collaborate with DOJ, FCC, CFPB, HUD, and state attorneys general. We have always tackled new civil rights challenges with new laws tailored to modern and present issues as they present to us. All of these laws, as well as state civil rights laws, play a vibrant role in protecting civil rights online, but they are not sufficient. If existing laws were sufficient, we would not be having this conversation. In general, existing laws were almost always enacted before the internet and are not calibrated to the data economy. For example, it is difficult, if not impossible, to apply many of them to algorithmic discrimination. And as we're seeing in various cases working their way through the courts, challenging discriminatory advertising is very difficult as well. And none of this has anything to do with Section 230 necessarily. Here are a few examples. In the employment context, Title VII only applies to employers and employment agencies, but there's a lot of other entities in the hiring pipeline that may not qualify, as well as advertising platforms carrying job advertisements that may not qualify as employment agencies. In the education context, there is no general anti-discrimination law specifically focused on education at the federal level. And so we're seeing low quality for-profit colleges targeting marginalized communities with low quality services. And most importantly, in the public accommodations context. A public accommodation is a business that offers goods and services to the general public, and it should not discriminate either by refusing service or offering services on inequitable terms and conditions. But federal civil rights protections for public accommodations have many, many gaps. Retail is not covered at all by Title II. Online gaming may not be covered. Social media may not be covered. Travel booking websites may not be covered. If any online coverage exists, it is hypothetical at this point. Under current federal law, online stores could charge women double the price of men or refuse service to Christians. Moreover, federal civil rights laws also do not protect all of the categories of protected characteristics that deserve protection. No federal civil rights law explicitly covers sexual orientation or gender identity as protected characteristics, although the Supreme Court's recent decision in the Bostock case has extended sex discrimination very significantly. Some statutes, like sections 1981 and 1982, only apply to race discrimination and a few other narrow categories. Even when existing laws may apply, history has shown us that it is not sufficient to rely wholly on private enforcement or on enforcement by government actors and regulators. Moreover, we cannot afford to wait 5 to 10 years for speculative lawsuits to attempt to implement new theories with old statutes. Harm is happening now, and we need new protections now. Thank you.
Thank you so much, David. Bert, would you introduce yourself and say a few words, please?
Absolutely. And thank you, Lauren, and thank you, Travis and Lindsay and the rest of the NTIA team for having us today. And it is always great to be on the same bill as Assistant Attorney General Kristen Clarke and Commissioner Slaughter and the rest of my fellow esteemed panelists. My name is Bertram Lee. I'm Counsel for Media and Technology with the Leadership Conference on Civil and Human Rights, a coalition of over 220 civil and human rights organizations that has been around for over 70 years. The Leadership Conference has been involved in every single major civil rights law since its founding, and is a major part of the Civil and Human Rights Coalition, and it is the leader in civil rights work. The civil rights community has been at the forefront of AI and civil rights and privacy work since at least 2010, but originally releasing civil rights principles for the era of big data in 2014. We re-released those principles in 2020 with a number of organizations and coalition members. Those include ending high-tech profiling, ensuring justice in automated decision-making, ensuring that technology serves people historically subject to discrimination, preserving constitutional principles, and defending responsible use of personal information and enhancing individual rights. And lastly, making systems transparent and accountable. A majority, if not all, protected opportunities now exist online, including many within the context of criminal justice, and specifically all of the areas that are protected by historical civil rights law. The civil rights community is not just asking for new policy around civil rights and privacy, but also enforcement of current laws, as there is no real enforcement mechanism, no matter how large or small platforms are within the context of protected opportunities as of now. Now, with that said, not all uses of data and AI are bad. There are much needed uses of AI, specifically within the context of giving opportunities to marginalized communities, but also allowing AI to help marginalized communities within the context of, say, sickle cell research for Black communities. But with that said, there needs to be transparency and there needs to be third-party audits. And historically, there's always been third-party audits within the context of civil and human rights enforcement, right? Or within the context of civil rights enforcement. Specifically within the housing and employment context, there have always been shadow buyers, or even within the context of employment, shadow resumes used to gauge discrimination along a variety of contexts. Right now is the time that not only we as a country, but really globally, have to think about AI within the context of civil rights, helping protect marginalized communities, helping protect those who suffer discrimination disparately at the hands of these large companies without any recourse. Now is the time for transparency. Now is the time for accountability. And now is the time for enforcement. Thank you.
Thank you so much, Bert. Aaron, I'll pass the mic to you. Welcome.
Thank you, and thank you for inviting me. My name is Aaron Konopaski, and I'm an attorney at the Office of the Legal Counsel at the Equal Employment Opportunity Commission, or EEOC. Some background, the EEOC is the federal agency that enforces the federal employment discrimination statutes, So specifically Title VII of the Civil Rights Act of 1964, the Americans with Disabilities Act, or ADA, which prohibits employment discrimination on the basis of disability, the Age Discrimination in Employment Act, which prohibits employment discrimination on the basis of older age, and the Genetic Information Non-Discrimination Act, which prohibits discrimination on the basis of genetic information, which includes family medical history. I wanted to start off by saying that because the statutes that we enforce are anti-discrimination statutes, with a few exceptions, those statutes are not centrally concerned with privacy, at least not directly. Rather than being concerned with who has information or whether we can withhold information from certain entities, our attention goes mostly towards how certain entities can use that information, specifically whether they can use it to discriminate against people. Nevertheless, privacy does perhaps play a role in what we do indirectly. And the reason for that is something that was mentioned earlier. In addition to prohibiting intentional discrimination on the basis that I mentioned, the federal anti-discrimination laws also prohibit unintentional discrimination. So in the case of Title VII and the ADEA, for example, we think of unintentional discrimination as being against groups. And the question that we ask is whether the employer is doing something that disadvantages a particular group, statistically speaking. If so, if someone shows that the employer is doing something that disadvantages a group in court, the employer may be required to legally justify its use of the practice. In the case of the ADA, the question is more individualized. And the question is whether the employer is doing something that disadvantages a particular applicant or employee because of that applicant or employee's disability. And again, if someone shows in court that the employer is doing something that disadvantages the person and the person loses employment opportunities as a result, then the employer may be asked to legally justify its practice and perhaps make an exception in the case of the individual with a disability, or look for an alternative method of evaluating. In terms of a couple of quick examples, in the case of Title VII, for example, one thing I have to say is that I can never declare whether a certain practice is unlawful absent particular facts, but suppose that we have an employer who uses zip codes as a factor in hiring. This example is taken from the news a little while back. And suppose that the employer favors zip codes that are close by over ones that are farther away. If race is unevenly distributed throughout the zip codes, you may have, in a situation like that, the practice having an unintended but significant effect on the basis of race. If the employer is favoring people nearby and they're of a predominantly particular race and the ones farther away are of a different race, then you'll have an imbalance in the selection. When it comes to disability, you can imagine a case in which a person had to take time off in the middle of their career for, say, 3 years. If you then have an employer who scans resumes for gaps in employment, you may have a situation in which the person is rejected for the position because of the gap in employment, which was caused by disability. And so in that particular case, the person might be, as we say, screened out because of their disability from employment. And in that case, if the person went to court, they would be required to, the employer might be required to justify its practice. And what does all of this have to do with privacy? I think it's just this, that we're entering an era in which people have a lot of data at their fingertips. People are gathering data all the time, and the amount is hard to underemphasize. And so if so much data are available, you're going to yet employers, people are worrying, that choose categories of data or types of data that are connected up with protected characteristics like race, disability, sex, and so on. Sometimes lawyers and others call these proxies. So employers might choose a type of data that goes along with race, is correlated with race, or is connected up with disability. And just because of the sheer number of data and types of data available, the worry is that that's inevitably going to happen. It's somehow going to make its way into one of these algorithms that employers use to make hiring decisions or employment decisions, and you're going to get these unintended consequences by using those types of data. And so that's where I'm going to leave off for now.
Great, thank you so much, Aaron. Lydia, would you introduce yourself, please?
Hello, this is Lydia XZ Brown, they, them pronouns, and I'm Policy Counsel for the Privacy and Data Project at the Center for Democracy and Technology. My work examines the ways in which algorithmic decision-making systems discriminate against and harm people with disabilities, particularly disabled people who are also marginalized because of race, gender, sexuality, or class. We know that tech innovation often enables access for disabled people and those in other marginalized communities, but technology can also cause and exacerbate ableist discrimination through both baseline inaccessibility, as well as through more complex means of discrimination by data. For disabled people, this can happen when companies use algorithmic systems that infer information about their disability status, or that tend to make adverse decisions that correlate with disability status. And certain people with disabilities are actually more likely to rely on biometrics and connected devices that require sharing significant amounts of very personal, intimate data, putting them at risk of heightened discrimination and exploitation in the absence of privacy laws that could otherwise protect people using data-driven technologies. In the employment context, Aaron was just speaking about this, more employers are turning to algorithmic tools for recruitment and hiring. Those tools might include resume screening software that looks for trends found in resumes of existing employees, but may unfairly penalize disabled people because of gaps in their resume or lacking indicators like playing on a sports team. Other tools might include automated testing, video or audio analysis that assess applicants' characteristics or personality fit for an employer, characteristics that might be unrelated to the job and may result in negative strikes against people with involuntary motor tics, who don't make eye contact, or who have anxiety or depression. Still, other employers use algorithmic management tools to surveil employees and track productivity, putting a range of disabled employees at risk for heightened scrutiny and workplace discipline for disability-related reasons. The ADA prohibits tests of fit unrelated to essential functions of the job, but enforcement is inconsistent and wanting. Job candidates may not always know when they've been discriminated against, especially by automated systems. But even when candidates do have a sense that they've experienced discrimination, the EEOC's uniform guidelines for employee selection processes don't reference disability at all. The EEOC needs to issue updated guidance addressing algorithmic tools and explicitly including disability. Landlords and property management companies are also using algorithmic tools more than ever to conduct tenant background checks and screening. These types of algorithmic tools used in credit decisions can result in denied applications based on characteristics associated with disability or disproportionately affecting disabled people. Software that automates rejection based on police contacts because of domestic violence related calls, past arrest records, or lack of sufficient rental history could potentially violate the Fair Housing Act's non-discrimination protections and the Fair Credit Reporting Act's requirements for accuracy in information used for credit purposes, including data related to reputation, and disclosure of adverse determinations. It also contradicts HUD's guidance against making housing decisions based on arrest records. Those systems can disproportionately reject disabled people who are more likely to experience domestic violence or be arrested and less likely to have stable housing. And especially during the pandemic, more people have used and relied on health apps to track physical fitness, make progress on health goals, and manage conditions including certain disabilities. These apps might collect incredibly sensitive data, much of it directly related to disability status, whether or not a particular user interface is even meaningfully accessible to disabled people. But use of data by health apps is not generally governed by the very narrow provisions of the Health Information Portability and Accountability Act, nor may it be covered by the ADA's Title III pertaining to places of public accommodation, because many jurisdictions don't apply Title III to cases where people receive a business's services from an online-only location. This is yet another reason why we need a comprehensive federal privacy law. Finally, disabled people are more likely to experience surveillance in a variety of contexts, often fueled by proprietary algorithmic decision-making systems. For instance, discriminatory data can and does result in disabled students being more likely to be flagged for suspicious behavior by automated proctoring tools, and in disabled people being identified as less likely to meet conditions of pretrial release on bail by risk assessment algorithms. And so while a small handful of companies have developed safeguards to protect consumer data, we need federal regulations mandating data safeguards, including restrictions on collection, retention, third-party sharing, and disclosure to consumers. Additionally, such regulations have to be accompanied by congressional clarification of regulatory and enforcement authority by the various agencies of jurisdiction, and sufficient resources to enable meaningful monitoring and enforcement of both private and public use. NTIA also has an opportunity to help disabled people by addressing our disproportionate lack of access to affordable broadband infrastructure and accessible devices and programs. I look forward to the panel discussion and welcome any questions or follow-up afterward. Thank you.
Thanks very much, Lydia. Michelle, I'm going to turn it over to you. Thanks for being here.
All right, thank you, Lauren, and to the entire team at the NTIA for hosting today's listening session. I'm Michelle Gilman. I'm a professor of law at the University of Baltimore School of Law. I direct the Civil Advocacy Clinic. I am supervising students who are representing low-income Baltimoreans in a wide range of civil litigation matters that touch on housing, consumer, employment law, public benefits, and more. And in my years in this practice, I've become increasingly concerned about the ways that digital profiling is adversely impacting my clients. Now, to be sure, all of us are emitting digital exhaust as we access the internet, buy goods online, carry around our smartphones, engage on social media, and so much more. All of that data, as we've discussed today, it's collected, it's aggregated, it's sold, and it's used by data brokers and so many other industries. And this is why you're probably barraged with online ads for a product that you may have glanced at only briefly online. And for many Americans, this is simply an annoying fact of life in the digital age. But for low-income people in this country, the harms extend far beyond the shared sense of creepiness and being tracked. And that's because of the gatekeeping function played by various consumer reports and automated decision-making systems that rely on digital profiling. So for example, and we've talked about many of these today, landlords use tenant screening reports to select who they're going to rent a home to. We've talked a lot about employers using various algorithmic systems to decide who they'll interview for a job and how they'll conduct the interview and make a decision. Doctors use healthcare algorithms to determine the level of care that a patient will receive. There's an entire sector of companies that focus on collecting data about low-income consumers in particular so that they can be targeted for subprime goods and services. And since we're talking about civil rights, it's important to acknowledge that being poor is not a protected status under anti-discrimination laws. So we've talked a bit today about how civil rights laws are a valuable tool for combating these harms, but don't go as far as we need in a digital era. And I just want to add that privacy law as well does very little to protect against the dynamics of both exclusion and targeting based on one's economic status as captured in a digital profile. This is troubling for many reasons. So we know that digital profiles are grossly incomplete. For instance, tenant screening reports will include information that a tenant was sued for eviction, but not include the disposition, even if the tenant won the case. These profiles are also riddled with inaccuracies, such as name matching problems. So this means that there are other Michelle Gilmans out there who have my data in their profiles and vice versa. But this is a much bigger problem for members of minority groups who have fewer unique last names. So for instance, the census shows that more than 12 million Latinos in America share just 26 last names. And even if these consumer reports are accurate, they often include factors that have no empirical connection to the desired outcome. So for instance, 1 in 3 Americans has a criminal record, but in the vast majority of cases, that record has absolutely no bearing whatsoever on the person's worthiness as a tenant or employee or college student. We need to be asking, who decides what gets factored into these algorithms, and on what basis are they making these determinations? And right now, we simply don't know for the most part because there's no transparency around automated decision-making systems. And that's partly because in the US, as has already been mentioned, we do not have a comprehensive data privacy law. We have a handful of sectoral laws that protect certain narrow pieces of Americans' financial and health information. But honestly, in over 20 years of representing low-income people, no one has ever come to me saying, I need help with a HIPAA violation or a violation of the Graham-Leach-Bliley Act. People are seeking access to basic human rights, housing, jobs, education, healthcare, and too often, as I've said, digital profiling is a barrier. So instead of a comprehensive privacy law, this country relies upon what is commonly called a notice and consent regime. And this puts the onus on individuals to safeguard their online privacy. So you're all probably aware that when you download a new app or visit a new website, you have to click a box accepting the terms and conditions of that provider. There are a lot of problems with this system. The first is that surveys show most people do not read those privacy policies. And that's completely understandable because they're lengthy, they're complicated, they're jargon filled. It's a lot of legalese and gobbledygook. One study showed it would take 25 days to read all the privacy policies that a person encounters in a year. And this is particularly challenging for less educated consumers who are more likely to be low income. And even if you do read and do understand the policies, you have no ability to negotiate the terms, right? Are you going to call Mark Zuckerberg to propose, edits to paragraph B, subpart C, little d, subpart F? Of course not. It's an adhesion contract. You're stuck with the terms. And once a consumer agrees to those terms, game's over, right? Consumers have no idea how their data is being used after that point. They have no ability to control it, to fix it, to delete it, or to obtain an explanation for a given outcome. So all this means that when I'm sitting in my law office with my students, the legal hooks to help our clients with regard to digital profiling harms are very, very limited. And the transparency barriers are huge. Most people don't even know they're being harmed by these digital profiling systems, and so they don't ask for or seek help. And even if they, can get a lawyer and I can make a request to understand a certain algorithm, it can be really hard to get an explanation because the entities that deploy these algorithms trade secrecy for these tools. And even if I can get my hands on it, it could be very hard to understand the source code. I'm not a computer scientist. And some machine learning systems are so complex that even their makers can't explain a given outcome. So we have at least those 3 transparency barriers to digital and economic justice. And so for all these reasons and many more, I would like to see not only vigorous enforcement of the existing laws that we've discussed today, but also new substantive privacy law protections to ensure that these automated decision-making systems are fair, are transparent, and are accountable. Thank you, and I look forward to the discussion.
Thanks very much, Michelle, and thanks again, everyone. I think those brief opening remarks really help set the stage for our conversation. I do just want to remind members of our audience that if you do have questions for this panel, would you please either put them in the chat or you can email Travis at thall, THALL @ntia.gov. Okay. With that, we have a few questions. So Aaron, I'm going to direct this first question to you. We heard a little bit from you on this, and Lydia offered some thoughts as well. As you and Assistant Attorney General Clarke mentioned, the EEOC is responsible for enforcing federal civil rights laws in the employment context. From that perspective, and you alluded to this a bit in your opening, could you describe what you and your colleagues at the EEOC are seeing now as the most pressing issues at the intersection of privacy and civil rights?
Well, I think you're cutting out at the end there, but I think I got the gist of the question. Problems for enforcement, of course, we may not know. We may not know what the biggest problems are, but certainly one kind of barrier to enforcement that we do know about has really been talked about a little bit already, which is a certain kind of lack of transparency. We are a charge-driven agency, by which I mean that generally speaking, for the EEOC to take legal action, somebody has to come to us first and say that something went wrong, say that they're the victim of discrimination and they want to challenge a decision that's been made. And especially in hiring, people don't necessarily know why they were not hired. They aren't told, well, you didn't pass the such and such test, and that's why we didn't hire you. More likely, they'll just get a denial notice. And it would take an unusual kind of person, I think, for the thought process to go, all right, I could look for the next job opportunity, or I could suspect that maybe something that the employer did while deciding not to hire me has something to do with my race or is connected somehow to a disability that I have. But that seems to me like a very unusual course of action, and they would have to go so far as to file a charge of discrimination to even get more information in most cases. So you have this lack of transparency, which is a barrier not only for the person who's applying for the jobs, but also for us, because generally, it requires that person to come to us first. And then the second thing is, if what you're interested in is privacy generally, and some of these data practices that people are using, employment discrimination law, you might find is inefficient, or in some cases, perhaps ineffective way to get what you're really after. There are a few direct protections for personal information. Under the ADA, there are certain restrictions on the kinds of questions, medical questions, that employers can ask employees and job applicants. And the Genetic Information Non-Discrimination Act has protections for certain kinds of information as well. But generally speaking, when you're challenging the use of data, you first have to show that the employer's use of the data has some kind of discriminatory effect first. And only then do you get to the stage of evaluating whether or not the employer using that data even makes any sense at all, right? So an employer could avoid any kind of disparate impact on a protected group, right? Suppose that the practice doesn't have a disparate impact on the basis of race, or one of the few things that I mentioned in my talk, and it doesn't happen to screen anybody out with a disability, then there's no reason for us to find cause, right? It doesn't matter how senseless the data tool is, or whether or not it makes sense, or whether it works, or whether it tells the employer anything of value or not. It doesn't violate the particular laws that we enforce. And so there's these two distinct stages where first you have to show that it has this discriminatory effect, and then only then do you get to the stage of evaluating whether the practice is a good one in the first place.
Thanks, Erin. Lydia, do you have reactions or thoughts based on Erin's response?
This is Lydia. Thank you so much for the opportunity to be here. And Erin, thank you for sharing your comments too. Fundamentally, we understand that privacy is a civil rights issue, right? And that goes to the heart of the comments that we've all made today. Privacy is a civil rights issue. And when we look at the ways in which data-driven discrimination affects people, that illustrates for us that privacy is not simply about being able to protect sensitive ideas. It's not just about what you want people to know about. It's not just about whether you're applying for a certain job. It is a civil rights issue. When data is used to make decisions about people, it affects our civil rights. It affects our ability to access the most basic needs that we have as human beings. And when marginalized communities experience disproportionately negative impacts of violations of our privacy, of use of our private information, that is a civil rights issue. And I know that in disability communities in particular, disabled people are often strategizing about what it means to attempt to uncover discrimination or to ask for enforcement of it. And I know that I would welcome continuing collaboration and conversation about how we can elevate disabled people's concerns and the experiences that disabled people continue to have over and over again with employers of all sizes in a variety of fields, using a variety of technologically driven tools that have tended to discriminate in ways that can be hard to detect, hard to uncover, hard to disentangle, and yet need further resources to be able to understand and to be able to act on so that we can actually get better guidance in place to protect disabled people and other marginalized folks in the future from being discriminated against and harmed by the very same tools.
Thanks, Lydia. Michelle, do you have a perspective on this from your practice that might be helpful with some examples of these issues?
Not really, because I'm not litigating civil rights cases. If I see civil rights issues, I know who to have my clients call. Call the EEOC. Call Lydia Brown. So, but what I am seeing is all sorts of algorithmic harms that need not just civil rights remedies, but also privacy law remedies, and also, substantive law remedies that work to knock out specific harms generated by algorithmic systems. So, one example is low-wage workers are often subject to unpredictable scheduling by their employers, and employers use these algorithms to determine schedules, and their schedules are all over the place, and people can't plan childcare or other jobs or balance family work obligations because they don't know week to week when they're working. And there are some jurisdictions that have, usually at the city level, enacted fair work week laws that guarantee the substantive right to know what your schedule is, well in advance. And so that's just an example of a type of law that knocks out the algorithmic harm entirely. And so we need to be thinking, I think, a multi-pronged approach of civil rights and privacy law, and also like substantive laws that get at the specific sort of form of decision making that's harming people. I think it's really going to be a multi-pronged approach, as I think the discussion today suggests.
Thanks, Michelle. Bert, I would love to hear from you first on this next question. You, in your opening remarks, talked a bit about the leadership conference's work over the last 70 years, and I'm interested if, from your perspective, there are principles or lessons learned from previous civil rights work that policymakers and advocates should be keeping in mind as they evaluate how to protect marginalized groups from exploitative data practices.
Thank you so much for that question, Lauren. I think one, the civil rights principles on big data that we put out last year would be a place to start. But I also would say that a lot of the problems that Michelle and Lydia and Aaron have highlighted, and David have highlighted, are problems that the civil rights community has been fighting for decades. Before AI could target communities with almost pinpoint precision, there were issues of advertisement discrimination in newspapers, right? The first disparate impact case, or one of the first key disparate impact cases, was highlighting how job discrimination was facilitated by not putting an advertisement in a black paper, in a mostly black paper, as they would in a white paper. And so these issues are old. The issues that we're fighting, specifically on housing, employment, credit, and I'll use the term protected opportunities, a term coined by Pauline Kim, to kind of like consolidate those things. When we're talking about protected opportunities, we're talking about opportunities that have now shifted online. Whether they are government benefits, whether they are employee or privately engaged entities, right? These entities all have contexts of protected opportunities online, and also different verticals are now existing within different companies, where multiple companies engage in multiple different verticals that are protected under civil rights law. One thing that the civil rights community, and particularly the Leadership Conference, thinks about is, what does robust enforcement now look like within the context of current law, right? Often people will say, within the context of civil rights, there has never been robust civil rights enforcement throughout the United States on a litany of laws that help solve a lot of these problems at the outset. But not only do we need robust enforcement, but we need to think through, what does civil rights protections in a privacy context look like? And how do we ensure that companies know their obligations with respect to civil rights moving forward? And most notably, I think there is an issue of kind of size, right? I think a lot of folks think, within the context of technology, that just breaking up companies is going to be the way to do it. And I'm not saying that folks shouldn't go that direction, but rather there is not a level of transparency in the most competitive digital marketplaces, whether you're talking about housing, employment, fintech, and credit, right? Some of the most competitive marketplaces have the least amount of transparency when it comes to how they are complying with current civil rights law. That needs to change, and what we need is an auditing, or at least a third-party mechanism, to ensure that people are engaging in non-discriminatory practices writ large. And that needs to be thought throughout the stack, throughout different verticals. How are we ensuring that marginalized communities are not being discriminated against, both from a data set perspective and what we're asking artificial intelligence and algorithmic decision-making systems to do? And that's a problem that is a company-led problem. And so therefore, companies should be responsible for not only auditing their AI, but making sure that it is public and transparent, and that it is clearly understandable by consumers and by individuals and by communities as they engage in their work. What we don't know right now is how deep the rabbit hole proverbially goes, but we do know we're dealing with some of the same issues. When you're talking about different companies deciding to give services or not give services to certain communities, they generally fall within redlining lines. That is a historical context that is replicating itself through artificial intelligence, right? There are a number of examples that one could just look through the news to find, of how companies and how entities are discriminating against marginalized communities, whether it's protected opportunities or education, healthcare, so on and so forth. We need to be thinking about, how do we prevent the use of artificial intelligence and algorithmic decision-making systems to further entrench disparities within marginalized communities, and as Lydia has noted, within the disability community moving forward.
Thanks, Bert. Does anyone else on the panel want to respond either to Bert's observations about lessons learned from previous work or his comments on the importance of third-party auditing of potentially discriminatory practices?
This is Lydia. I'll take that question. Disabled people have long used the slogan, "Nothing about us without us." This dates back to activism by disabled organizers in South Africa and Eastern Europe, decades. The core philosophy behind that statement is that if we're making policy or implementing practices that affect disabled people, especially if they're about disability, but even if they're not focused on disability and simply affect our lives, then disabled people need to be not just included in those conversations, but we need to be partners. And we see how disabled people have continually experienced exploitation and extraction of our knowledge, of our data, of our literal biological, biomedical information to fuel and to fund research that is often done by people who don't have disabilities and who are not working on goals or outcomes for the betterment of actual disabled people and in accordance with the priorities that disabled people have for ourselves, especially those of us who are from multiply marginalized communities. Disabled people whose data is going to be used for research have to be part of the process in setting the priorities, in setting the parameters, in agreeing to and in thinking about what the outcomes are going to be of that research and of tools and systems that will be developed coming out of that research. We know that marginalized communities, disabled folks, Black and Indigenous people, trans people, immigrants, low-income people, incarcerated people, and homeless people all have experienced histories of exploitation and extraction for research purposes by researchers, data scientists, and policymakers who don't come from our communities and don't share our communities' goals. And if we don't develop good collaborative research practices and data practices from the beginning, then of course we're going to see discriminatory and harmful outcomes. This is also what happens when policymakers and when civil rights advocates are not collaborating with the people who are most impacted and who are directly affected by issues of marginalization and discrimination from the beginning. In the 1960s, the civil rights laws that we passed did not include disability at all. The ADA wasn't passed. 25 years. This led to major gaps throughout our regulatory and legislative history where, for example, the Uniform Guidelines on Employee Selection literally don't include disability. I mentioned that earlier, right? And so this has resulted in people who are at the margins of the margins, disabled people of color, disabled people in the LGBTQ community, queer women of color, people who exist at the intersections being the least likely to be able to assert rights or protections under our existing laws. When we're thinking about now devising stronger and new regulations and legislation, we have to remember that we are working to protect all marginalized people, not trying to silo communities as though we are not interconnected, as though disabled people somehow exist in this sphere all by ourselves. We know in the disability community that disability is more prevalent in every other marginalized community than it is in every analogously privileged one, if only because of the impacts of systemic racism, of class-based discrimination, of gender-based discrimination that disproportionately fall on disabled people, that create conditions that exacerbate and cause disability, and that disabled people likewise who belong to other marginalized communities face the compounded impacts of civil and human rights violations that can't be distilled down to siloing individual groups as somehow separate from one another. When we're thinking about what laws and regulations we're going to pass going forward, we cannot leave anyone behind, disabled or otherwise.
Thanks, Lydia. Michelle and David, I'm really interested in your perspective on this next set of questions. First, we've talked some already about the gaps in the current legal framework, but I'd like to know from your perspective, Michelle, you can take this first. Where do you see the current legal framework, if anywhere, being effective in addressing the impact of unfair data practices on marginalized groups?
Yes, thank you for that question. Well, one sort of hopeful sign are grassroots movements, like really coming from the ground up, sort of as Lydia refers to, that are coalescing around challenging these systems and these harms. And I think if we follow where a lot of grassroots activists and people on the ground are pointing us, we will spend our energies in the right direction. So along those lines, there has been really important work being done in the civil rights field, such as, a lawsuit that's pretty prominent right now challenging attendance screening algorithm because of the undue weight it gave to criminal records and the disparate impact that has on minorities. So there's some really creative thinking going on in the civil rights community and the poverty law community around these algorithms. There's been exciting work challenging private algorithms that are bought by government agencies and then deployed on people in ways that are denying them access to government resources. And that triggers a lot of protections around due process that don't apply in the purely commercial field. So lawyers are gaining increasing expertise and confidence in litigating algorithms, but there is no doubt that this field is in a very, very nascent stage, needs so much more support and partnership with government agencies like is happening today, and also with tech experts and bringing technologists into the fold to challenge these systems together. And I think one move that could make these systems better from the outset so that we don't have to rely on litigation at the back end to clean up systems after people are already harmed would be to bring more stakeholders to the table at the time that systems are adopted, when they're designed, and then throughout their life cycle to continue monitoring them. There's so much that impacted communities have in terms of the expertise on how these tools affect and shape their own lives that could be brought to the table. Right now, we have a real class divide between the people who develop and design tech and the people who are impacted by it. And certainly, I would say from a corporate perspective, it's beneficial, obviously, to have more consumers and a larger market. And so by bringing more stakeholders to the table, we could limit sort of the sorting and segmentation effects of digital profiling that are really trapping people on the lower rungs of the economic ladder. It's really hard to escape a digital profile, which for the most part just encodes digital hardship permanently and forever. And so I do see audits, as Bert mentioned, as really important on the sort of on the back end to make sure that algorithms have non-discriminatory outputs, but also on the front end, we probably need a tool like algorithmic impact assessments or some sort of process that slows things down at the front end to assess how algorithms are going to work with a variety of stakeholder voices. And so sort of attacking the problem both on the front end and the back end, I think, is a recipe for really reducing these harms significantly.
Great. Thank you, Michelle. David, I want to make sure we hear some more from you. I would like to hear both your thoughts on how and if the current legal framework is being effective in addressing any of these impacts. And, given the work that you and the Lawyers Committee have done, could you describe some of the limitations of the current legal framework and how those gaps might be filled?
Sure. So I want to touch on 2 or 3 specific things here. The first is unfair and deceptive practices laws and state consumer protection laws. In terms of things that work well, these are some of the best and strongest and most flexible laws. When we see enforcement actions against companies or other actors that are engaging in discrimination, we are often seeing it from state attorneys general using their consumer protection authorities. In addition, the FTC and the FCC have similar authorities, but in many cases, they don't have enough resources to enforce at the level necessary to really police the industry. Or in the case of the FCC, for a while, it was not necessarily a priority. But one thing I will note is in the new infrastructure bill, for example, it directs the FCC to engage in a digital discrimination rulemaking. And so I'm optimistic that the commission will take this opportunity to address discrimination in the tech telecom sector. The other area that I think has historically worked well and is evolving and getting better is public accommodations. So, historically, public accommodations has been this catch-all anti-discrimination statute or set of statutes that address different areas of the economy where other things don't apply in a sectoral way. And what we have seen historically is that the expansion of public accommodations laws doesn't just result in enforcement against specific businesses engaging in discrimination. It changes the social norm about what type of behavior and business practices are acceptable. You don't need to sue every hotel, gas station, and restaurant that engages in discrimination to shift the majority of businesses towards a better compliance model and towards a better, more inclusive way of doing business. And what we're seeing in terms of online public accommodations is that there are a number of jurisdictions, I believe currently 7 jurisdictions, that already apply their general anti-discrimination laws to the internet. That includes California and New York. So you already have Silicon Valley and Wall Street covered. The New York statute also includes disparate impact protections. And just in this last year, earlier this year, Nevada expanded its law to apply online. It was the first state to ever do this legislatively. The other states did it through court cases. And just, let me see here, 12 days ago, a new law came into effect in the District of Columbia, expanding its law as well. And similarly, just last week, Attorney General Racine in the District of Columbia introduced new legislation around algorithmic discrimination. So I think there's really a lot that can be done with online public accommodations. And that sort of leads me into the third thing I want to talk about, which is disparate impact. And it's the central importance of it, and both in existing civil rights law and as we address these new challenges. The traditional disparate impact test works really well, and we have decades and decades of case law applying it to lots of nuanced situations. And so when we are talking about creating new anti-discrimination protections in an online context, what we are really talking about in many instances is applying the traditional tried and true disparate impact test that has been well understood by everyone for decades. And part of that is understanding that not everything that creates a disparate impact is automatically unfair or illegal, right? You can have disparate impacts that go through the test and you say, you know what? This is a legitimate use, even if there is a disparate impact here. So the test is, first, is there a disparate impact on the basis of a protected characteristic? Second, is the entity engaging in that practice, do they have a legitimate reason for doing what they're doing? And third, is there a less discriminatory alternative that they could reasonably use to obtain that legitimate interest? And so I think it's really important for folks who are encountering this material for the first time to understand that just because something has a disparate impact does not necessarily mean it should automatically be illegal. To give an example, right, that will be very applicable to sort of the online sector. Suppose there's a restaurant that wants to, that's a neighborhood restaurant. It doesn't, it's a small place. It's not having people coming from far away to eat at this restaurant. And the restaurant's in a racially homogenous neighborhood. And the restaurant wants to advertise narrowly to the neighborhood it's in because that's who its clientele is. That's the only people that are reasonably going to come to this restaurant. And so it wants to run an ad that is location targeted to some radius around the restaurant that's some reasonable distance. Well, that advertisement is probably going to have a racially disparate effect if that area is racially homogenous. But that use to advertise in that way is legitimate and would probably be permissible. So you know, there's things we have to think about there. The other thing we have to think about as we're thinking about how to apply disparate impact tests and these other rules is we have to ensure that we are creating smart exceptions to protect things like diversity, equity, and inclusion efforts and other beneficial uses. And you know, that's part of the reason why it's really important that we need an agency with rulemaking authority in this space so that they can address the nuances and keep up with technological changes.
David, thank you so much. That was really a really helpful synthesis, and it segues nicely into a big question that we have about 5 minutes to answer definitively as we wrap up our panel. We have a question from our audience, and that is, several of you have mentioned during our conversation the need for comprehensive federal privacy legislation. We should be able to address this in 5 minutes, don't we think? Could you talk about, and I'll let you jump in, you know, if you want to speak first. Could you address what protections you think absolutely should be included in this type of law? What agency or agencies should be involved in regulatory and enforcement functions, and share your perspectives on what should be included, and we should make sure we don't forget in comprehensive federal privacy legislation. Someone want to kick us off?
I'll jump in really quickly and just say that civil rights protections must be a part of any comprehensive privacy law. They must. Chuck Schumer, Senator Schumer, Senator Cantwell, and a number of other leading Democrats on bicameral in both the House and the Senate have already committed to doing that, and we need to ensure that it does, because we need clear rules of the road and we need clear non-discrimination language within the context of any federal privacy law.
And if I could just add to that, I'll note that it's bipartisan as well. In the House GOP privacy bill that came out several weeks ago, there are good anti-discrimination protections as well in there that could provide a good starting point for thinking about how to frame these issues. And I'll also note, you know, the Equality Act, which has very, very broad support from members of Congress, from advocates, from many companies, including across the tech and telecom sector. The Equality Act likewise includes protections for online public accommodations. So I think that there's a lot of room to work with here. I would say, you know, in terms of specific things, we want to make sure that discriminatory data uses are prohibited with regard to important economic opportunities like housing, lending, employment, education, insurance, and public accommodations. And there needs to be substantive regulation of algorithmic bias and algorithmic transparency, probably something that involves risk assessments before deployment and impact evaluations post-deployment. And these various measures should address intentional discrimination as well as disparate impact. There needs to be an agency with rulemaking authority to implement some of this stuff, because the technology is going to move faster than Congress can keep up. And there needs to be a private right of action so that individuals who are harmed can vindicate their rights in court. A private right of action is a central feature for almost all civil rights laws, and it's a recognition of the fact that historically marginalized communities could not rely on the government to protect their rights. And so often those rights need to be directly protected. And also, finally, a law needs to make sure, as I discussed before, it has smart exceptions for legitimate uses, such as protecting diversity, equity, and inclusion outreach.
So I'll add a few things to that excellent list that should be entirely nonpartisan, that should be bipartisan and achievable. One thing that would help me as a lawyer representing low-income people is if we had a right to an explanation in this bill, so that if someone is adversely impacted by an algorithmic system, they can understand why and how they why and how the algorithm works the way it does, and why and how they were impacted the way that they were. I think it's really important for algorithmic decisions that impact like core human rights and civil rights, for there to be a human in the loop at some point, so that at some point in the decision-making process, someone impacted by one of these systems can talk to a human being and not solely be subject to the automated decision-making system. I think we need to think about certain rights to delete information, so that, as I said earlier, someone's economic hardship isn't digitally encoded and used against them to trap them in a cycle of poverty forever. And I do think there should be legal requirements, legal mandates for public participation in the development and evaluation of these systems. As we already mentioned, audits could be a tool, algorithmic impact assessments could be a tool, but we need public participation mandated, just as we do with environmental laws. So that's not really a radical idea. There are a lot of legal regimes in the United States where we mandate that voices of the public be heard. So that's 4 things I would add to the excellent suggestions put out by David and Bert.
This is Lydia. Oh, I'm sorry.
No, please go ahead.
This is Lydia. I would add that when we're talking about auditing and impact assessments, we need to make sure that any comprehensive federal privacy legislation that mandates audits mandates that those audits be conducted by third parties. When companies or agencies attempt to audit themselves, it's not trustworthy in the same way as having someone who is outside be able to audit that system and to have the results of that audit be publicly available. And in particular, and Michelle's talking about this a little bit too, to make sure that people who are directly impacted by the systems, the people who actually have the most to lose, are involved in any auditing and impact assessment that takes place regarding either private use or public use. In particular, for disabled people, thinking about privacy risks that disabled people have, because many of us are actually more reliant on technologically driven systems, we have to be thinking about what trade-offs disabled people already always have to make about giving up our privacy or having to disclose or having to have sensitive information shared simply because we might need access to certain benefits or services that people who don't have disabilities are less likely to need, or not have to disclose as much information in order to be able to receive or to access in the first place. So when thinking about someone's ability to decide meaningfully whether to opt in or opt out of a particular form of data collection and usage, we have to think about the ways in which disabled people currently haven't always had an equal opportunity to be able to meaningfully opt in or opt out of certain technologies. And when disabled people are experiencing consistent invasions of our privacy, of our ability to make autonomous decisions, of our ability to be able to lead dignified lives, because our ability to access necessary services or benefits is predicated upon disclosure of highly sensitive personal information that other people do not have to share, then that's really a problem for our communities. There's a lot of power imbalances in decisions about who has to be subjected to what kinds of technology and who doesn't. Even just in the employment context, where your ability to secure a job is directly related to your ability to secure housing, to secure food, to have access to healthcare under our current political and economic system, if disabled people are more likely to be applying for jobs where the employer is going to be using and hiring-based algorithms than people who don't have disabilities that might have more of an opportunity to apply for jobs that were never posted anywhere, jobs where they could be considered individually by a human reviewer, then disabled people are going to be more likely to be affected by the use of those kinds of potentially discriminatory hiring technologies.
Thank you so much, Lydia. I want to, extend my thanks, the thanks of NTIA and the U.S. Department of Commerce for being with us this afternoon and for sharing your really thoughtful perspectives and expertise and passion for these issues. I am going to pass the mic to Travis, who's going to introduce the public listening portion of today's event. But thank you so much for this really excellent conversation, which I think does hopefully exactly what Travis wanted to do and help help flesh out some of the factual basis for this conversation. So thank you all so much. It's been a pleasure talking with you.
Exactly. So this is Travis Hall. Again, I am with the National Telecommunication Information Administration with the Department of Commerce. And thank you so much to, again, Assistant Attorney General Kristen Clarke, to FTC Commissioner Slaughter, and of course to all of our panelists for a really, really in-depth, fascinating, and helpful conversation setting up now the public listening portion. Now, for public participation, now I'm just going to do the full rules of the road. Again, the listening sessions are going to be available, are on Microsoft Teams. We can accommodate up to 300 people. And virtual participation via Teams desktop mobile web application will be placed in attendee mode without access to the camera or the microphone, unless you want to participate in the public listening session. These events are going to be recorded and transcribed and made available on our public website. And live captioning is available through the Teams desktop, mobile, and web applications. Live captioning must be enabled by the individual participant. For the participation in the public portion, participants should use the raise hand function to indicate the desire to participate. We will be then keeping a running tab and queue, and if the participant called upon, we'll temporarily enable your microphone and video for that for you to talk and it'll be for 3 minutes. Participants should note their name and affiliation as they raise their hand. If you're dialing in or if you're having trouble with chat, please email me at thall, THALL, at ntia.gov. Again, THALL at ntia.gov with the subject line listening session phone question. With your question in the body of the email, along with your name and affiliation, and we will, and then we'll get you on board. Just to put it out there, you can actually, as a phone participant, raise your hand with *5, and we will unmute you and call on you and let you ask your question. You can also post questions in the chat at any point in time. Or anything else that you'd like to add relevant to these sessions. We will be monitoring, of course, the live chat, video, and audio, and we'll move participants who are attempting to disrupt the proceedings. And with that, we actually do already have our first participant queued up. So Ryan, if you could get Andrew Liddell up and running.
Hello, can you see and hear me?
We can see and hear you. Thank you so much.
Excellent. Well, thanks, Travis, and thanks everybody for a wonderful session so far. Well, good afternoon. My name is Andrew Liddell, and I'm a parent, a lawyer, and one of the co-founders of the Student Data Privacy Project. The SDPP is a grassroots organization that has coordinated a national effort among parents to request from their school districts what information is being collected about their kids through online platforms and how that information is being used. We focused on privacy because FERPA is the only law we could find that gives parents any rights to receive this information and that imposes any obligations on school districts about what they can do with it. The threats to privacy and civil rights that are being raised in these listening sessions are felt even more sharply in a school environment than the consumer economy at large. And despite our name, my group's concerns transcend privacy. For example, what happens to a child or to a nation when we turn surveillance capitalism loose in our country's schools? What inequalities are we perpetuating? What opportunities are we foreclosing? What are the effects on a child of a lifetime exposure to manipulative design techniques? What is the result of having a permanent dossier of every thought, every hope, every fear, every failure, every impulsive decision collected about you starting at age 5 and available for sale to the highest bidder? Julian Lucas wrote an article in this week's New Yorker, I was actually reading this morning, about the lengths that professional writers will go to free themselves from the distractions of their devices. Even acclaimed successful authors like Zadie Smith, who have to write and therefore focus in order to make a living, are unable to control themselves in the presence of the internet. But what individuals experience as distraction, companies experience as profit. Clicks, eyeballs, and DAUs are how today's technology behemoths make their money. The more time you spend with them, the more money they make. And these companies possess the tools that can literally drive us to distraction. Through the techniques of so-called persuasive design, companies have been refining ways to hook users for the better part of the last decade. Whether it's Google or Facebook products that have been adopted by schools, or education market apps like Prodigy, they all share the same imperative to collect and retain as much information using all available means. There's no law stopping these companies, so they do whatever works. Minors and students are a marginalized group. They have no ability to vote for their school board members. They have no say in what technology is adopted in their schools. They have no power to refuse the conditions imposed upon them, and they have no understanding of the consequences of consenting to pervasive data collection. Never mind that in many other contexts, minors are unable to legally give consent, and parents are forbidden to consent on their behalf. And never mind that in the click wrap context, consent is basically illusory. Children are further marginalized because they can all be viewed as having a disability in some sense. Their brains don't finish developing until they're 25. And until then, they are physically incapable of practicing the kind of self-control that eludes even the most acclaimed professional writers in the world. We should not be holding our nation's first graders to a higher standard than Zadie Smith is able to achieve. Children have a right to an education, which means they have a right to learn in an environment that is conducive to learning. Let's take seriously the idea that a modern computer is not a benign productivity tool, but instead it's an agent that wants things from us. It wants our attention in order to capture more information about what we think and what we do for the benefit of some of the largest and most powerful companies in the world. Let's enforce the laws we have, including FERPA and including the ADA, and let's pass new ones that can return our nation's schools to being places for public education and not private profit. Thank you.
Great. Thank you so much, Andrew. Really appreciate that. Once again, for those of you who would like to participate, this is the public listening session portion, and we actually really do want to hear from you. Please raise your hand and let us know in chat that you are interested in participating, or shoot me an email, and I can ensure that that we get you on. Especially if you're on the phone, it's very helpful if you can shoot us an email. And one thing about my past is that I used to teach, and one of the lessons that I learned from that is sometimes you actually have to let a little bit of silence happen sometimes for folks to choose to chime in. So I'm sure that there are many of you who have lots of really interesting and deep thoughts on this issue. Maybe some of you are thinking that you need to save your thoughts for the second or third listening session, and I assure you that that's not necessary. And for anyone who would like to participate, please go ahead and again, sounding a little bit like a talk show host, raise your hand or let us know in the chat that you would like to participate, and we would be very happy to get you on the record. So currently we have 97 participants, and I would love to hear from some of you about your thoughts about what was said today, about any of the different topic areas, either be it civil rights law, privacy law, or just simply the topic of the intersection of privacy, equity, and civil rights. Tell us what we should know, tell us what we're doing wrong, tell us what we should be thinking about. Again, go ahead and raise your hands in the chat function or shoot me an email. My email address is thall, THALL, @ntia.gov. Again, thall@ntia.gov. And once again, I'm sure some of you have some talking points lined up maybe for the next session or the third session. You're welcome to share, a little, to tease it, to bring us, give a little bit of that today, and we absolutely welcome your participation. All right, I see that we have Marissa who has raised her hand. Marissa, could you please state your name and affiliation? Ryan, if we could get Marissa on into participant mode.
Hi, yeah. I'm Marissa. I suppose I would call my affiliation as a private citizen. I was wondering, so I saw these listening sessions, was intrigued by them, and I was wondering what you think the likelihood of active legislation coming out of these listening sessions would be. I know that a lot of this is informative and wanting to create more of a dialogue and getting public feedback and presenting thoughts and things like that in a public forum style. But I suppose I was just wondering how proactive you think this will be to the administration.
That is an excellent question. And so I put it out there that people are making comments. You're absolutely welcome to ask questions. So what we are doing here is we do have these 3 listening sessions. We will be following up with a formal request for comment where you can submit written comments sometime in January. We are not going to be putting that out during the holiday season. And then we're going to be taking all of this information and writing it up into a report. That we will then be using hopefully to have the administration both on the record, but then also use it as an opportunity for the administration to think through some of these issues through, again, the framing of, there's a lot of different issues, think through the issues of civil rights and equity through, some of the conversations around privacy, and likewise looking at privacy through the lens of equity and civil rights. In terms of it being proactive, I don't know how proactive you think a report is, but for us, that's as proactive as it gets in a lot of ways. And hopefully, that does lead to some additional action. So we do have a question that got sent in that that is actually being posed to all of you so it's a little bit of discussion fodder, and that is, what are participants' thoughts on mandatory data sharing for accountability purposes when it may seem to go against individual privacy interests, like large social networks being required to share certain data with academic researchers? And I know that some of our panelists are still on board. Welcome some thoughts, not only on the questions that, the overarching questions, but on that question in particular, if anyone would like to chime in. So again, just to reiterate that prompt question that did come from Stacey Gray from FPF, which was, what people think about mandatory sharing of information, for example, with academic researchers or third-party auditors. We heard a lot about that, where it, in terms of some definitions or conceptions of privacy, that might seem to go against privacy, but would, perhaps serve some of the larger, the Future Privacy Forum is FPF, and the larger kind of question around what where it might seem that civil rights and privacy rights might go against each other. So Bert, go right ahead.
So I think that we don't necessarily have to bifurcate those things. I think there are ways in which we can think about being privacy protective and also sharing data. I think about kind of like census information in that way, and census data. But with respect to kind of like third-party audits, right? This is why the audits should be with third parties. Those third parties should be certified. There should be a number of protections for those third parties and for the companies as well, because like we don't want kind of like personalized information to just kind of move out regardless and just be spread, but also within the context of what data should or should not be shared. We don't know the full extent of the data that these companies have to begin with. And so when we're talking about transparency, we're also talking about the standpoint of what data do companies and advertisers and all sorts of other entities, data brokers have with respect to our user data, and that data disproportionately impacts marginalized communities and how that data is used, particularly along protected opportunities and variety of different contexts as well, as many of my fellow panelists have highlighted. And so I don't think we should be thinking about it from the perspective of I don't think we should be thinking about it from a perspective of what to exclude, but rather what data would be good to include, right? Of course, we may want certain data from certain zip codes. We may want to be able to say, like, how is this location being treated? If, for instance, within the context of Washington, D.C., where I'm from, how is Anacostia treated versus how Chevy Chase is treated on a number of contexts is just something that is specific, not only to zip code, but to area and to region. And so how we're thinking about data sharing should be one that is, one, privacy protecting, but also shouldn't limit us in a way to say that we should not be sharing information to be able to prevent civil rights abuses in those contexts. I don't know if that answers the question, Travis, but
Bert, I think that was extraordinarily helpful. Thank you so much. Michael DeSantis has his hand raised. Ryan, if you could get him into participant mode. Michael, are you there?
Hello?
Yes, we can hear you.
Hi, my name is Michael DeSantis. I work for the Government of Canada at the Innovation Science and Economic Development Department. I do privacy policy and legislation all day, and my question relates to this sort of American perspective on privacy. So, what would some of the obstacles be in the American context for enacting a federal privacy law? I know for us we have some constitutional challenges and some issues relating to federalism, and I wonder if there'd be similar challenges in the United States, assuming like the political will exists and that you guys are full steam ahead for a federal privacy law. Like, what would some of the uniquely American challenges be?
Does anyone want to field that question? We've got another hand. We've got Carmen from Free Press. Brian, do you want to get Carmen online?
Hello, I wasn't going to answer the question. I just have an additional comment, if that's okay.
Yeah, go ahead and do your comment, and then either others can answer the question, or if we have dead silence again, I will circle around.
Okay, so I'm Carmen Scorado. I'm an associate legal director and senior counsel at Free Press. We're an internet advocacy organization, and I really greatly appreciate this discussion today about the intersections of privacy, equity, and civil rights. One of the things I wanted to flag for you all, and so something to take into consideration, is that the language that people speak also needs to be a component of this inquiry, because algorithmic discrimination, transparency, accountability, and enforcement can't rely solely on English-speaking people. And here we have a linguistically diverse communities, especially in the US. We have Spanish, Vietnamese, and so forth. And we want to ensure that people's rights are protected and they're not disproportionately harmed simply because of the language that they speak. So I think that just needs to be an additional dimension as this inquiry moves forward.
Great point. And I'm going to repeat Michael's question just because it was a little bit low volume. And that was just simply, asking about, from Canadian perspective, they have been able to pass some privacy law, and they're wondering what some of the potential hurdles are, what some of the potential process is in the US context. And again, I'm more than happy for others who are experts out in the field to weigh in or to take on that question, or again to raise your hand if you have other items that you'd like to raise, like some of the very relevant and very important points that have been raised so far. Or potentially to take on future privacy forums question that Bert responded to, which was the ways in which privacy could potentially be seen at odds with some of the mechanisms that would be needed to enforce civil rights provisions. Michelle, go ahead. And you are on mute.
Sorry about that. I've only had 2 years to learn how to unmute myself. I thought I would just address 2 of the political barriers that seem to be stymieing passage of comprehensive privacy legislation in the United States. One, I think it was David who already mentioned, is this issue of a private right of action. So the Democrats generally favor having private enforcement of a privacy law in addition to government enforcement, whereas the Republican versions of the bill would not grant a private right of enforcement. So that's a real sticking point. And the second major sticking point is the issue of preemption. So would a federal privacy law preempt the states from doing what they want and being creative? So for Democrats, they don't want preemption. They would say a national law should be a floor, not a ceiling. And for Republicans, they are advocating for one uniform law that companies could, comply with a national standard and be done. And those 2 sticking points come up session after session. And from what I see, and I welcome input from others, but those seem to be really what's blocking what in other ways is a lot of agreement that we need more privacy protections in the US.
Great, thank you so much. And again, for those of you who'd like to participate, go ahead and raise your hand. And I would be happy to call on you. And we do have a question that got emailed to me from Katarina Kopp from the Center for Digital Democracy. And so I'm going to go ahead and read that out. Should there be some applications where AI is not allowed ex ante until proven safe with regard to equity and civil rights? For example, AI applications for children could be handled with more care so that AI applications are only allowed until proven ex ante that they do not produce disparate treatment or impact. Or in the area of health applications and their impact, are there other areas? And again, I think that this was a little bit directed at some of the panelists, but of course, we have lots and lots of experts on the line. Would welcome others to weigh in. Bert, go right ahead.
And I think I'd answer Katarina's question by looking at, I think the historical context for thinking about these things is incredibly important. I think that when we're talking about the history of housing, the history of lending, the history of employment, the history of our criminal justice system, the history of education, all of those industries and all of those kind of verticals have large amounts of discrimination within them historically. And so any data that you pull historically in those industries, insurance is another one, right? Any data that you pull from those industries disproportionately, I would say, marginalizes communities and has a disproportionate impact on marginalized communities, particularly in the criminal justice context. Facial recognition comes to mind on some of these things, use within the context of the criminal justice system, education scores and scoring. I mean, there is a ton of research on the disparate impact of SAT scores on marginalized communities, right? And as Carmen also highlighted, non-English natives, right? If you didn't grow up in a home that didn't speak English as a first language, you have your SAT scores suffer in a lot of contexts as well. Or if you come from poorer environments, or if you come from economically disadvantaged environments, those also play a role in that as well. And so as I think industries and companies are thinking about using algorithmic decision-making tools and artificial intelligence to solve some of these problems and insert themselves into these different nexuses, they first have to really question, what are they trying to solve and how are they, if not I'd say adjusting for, but thinking about how historical biases play a large role within those sectors, and thinking about those things as well. And so I would just say that there are a number of industries where we should be really cautious about using algorithmic tools because of the historic impacts that those tools have had on marginalized communities.
Thank you so much, Bert. Let's go ahead and go to Daryl Cooper.
Hi, this is Daryl Cooper. I'm an attorney with the Disability Rights Office at the FCC, and I had a question that kind of bridges what you guys talked about earlier about government uses of private information in order to help people, in this case with disabilities, we have a gem of a program called the National Deafblind Equipment Distribution Program, where we distribute free equipment, free communications equipment to people who are deafblind and are low income. And the reason this is necessary is sometimes a braille reader might be $5,000. One of the challenges is finding the people who need these products. We partnered with people throughout the 50 states. We try to get a local state program to do outreach to locate an eligible person. And then once you locate the person, we provide an assessment, figure out what equipment they need, provide training. So it's a really, really good program. And like I said, it's for people who are deafblind. Traditionally, there's a lot of fear in the community of self-identifying. And so that makes it a challenge for us as well. So this is kind of a comment and a question of, how would any kind of law accommodate like reaching out and trying to find people who need a benefit?
This is Travis again from NTIA. Daryl, thank you so much for that question and comment. Certainly a very interesting use case scenario, posing it out to the group of if there's anyone who would like to weigh in, either again from our panelists or of course from the community at large, if anyone is interested in raising their hand or shooting me an email if you're on the phone, letting me know that you would like to participate. And Andrew and Carmen, I see that your hands are still up. I'm not sure if you are hoping to weigh in again with a second thing, or okay, you're putting your hands down. I'm guessing that means no. So a lot of really interesting, different kind of like topics that have come up. Let me just simply talk through that just a little bit, maybe get people's participation juices growing. Again, we have talked a bit about some of the panel focused primarily on the ways in which privacy laws and civil rights laws should be used and enhanced. However, some of the questions that have come up in the panel is the ways in which there may be some difficulties or some tensions within that space where there, and again, this came up in the panel a bit, where thinking through some of the exceptions that may be needed, and what some of the additional limitations might be on either side, or adaptions. Maybe limitations is the wrong word, but adaptions that might be needed on either side. And we do have a question that got just sent in. The question of like, what is the difference between a floor versus a ceiling approach to the law, and in terms of having hard stops on what companies need to do in order to comply, seems like an inadvisable solution to a dynamic situation. So I think that, to that second point, right, of this is from Marissa Parks, who sent in this question. So this is an interesting question that we've grappled with, certainly in terms of some of the questions around context and the way in which you have, different contexts and solutions being fairly contextual for both privacy and then also for civil rights laws, but the way in which you craft the law such that they're dynamic. And this was, I think, directed at Michelle, but I think that I'd welcome anyone weighing in on that kind of consideration about floor versus ceiling, and then also, putting in hard and fast rules on dynamic text situations. Let me just go ahead and take the moment of everybody thinking really hard about a response or an additional comment or solution to note that that my name is Travis Hall. I am with the National Telecommunication Information Administration, for those of you on the line. For those who would like to participate by phone, please feel free to email at thal@ntia.gov and we'll get you unmuted. If you're in the Teams native app, feel free to just raise your hand and we will call on you. Again, also, if you're on the phone, you can raise your hand by pressing *5, which is a pretty nifty feature that I didn't know about until 2 days ago. All right, I'll put out the call one last time for any final comments, anything that people would like to raise. We do have, again, 2 more days of listening sessions, tomorrow and Thursday. I know that some of you are saving your juice for the next 2 days, and I'm really looking forward to those for the participation there. Tomorrow, we are extraordinarily excited about participation from Alatanya Sweeney and the CPPA chair, Jennifer Urban, as our keynotes. And then on Thursday, we are really honored that our Deputy Secretary, Don Graves, is going to be giving keynote remarks. And we have a rock star panel, just like we did today, both tomorrow and on Thursday. And tomorrow's focus will be on the question around structural inequity. Focused a little bit broader, taking it like out of the context of the law a little bit into questions around, design, and other ways in which personal data flows might create or might be structured such that they alleviate structural inequities. And then on Thursday, we will be looking at the question that we have been talking quite a bit about, which is today, which is solutions. What can we and what should we do about this? And so I'm going to give folks 1 more minute in case you have some insights to share, anecdotes to share, thoughts that you would like to share. And with that, I think that we can wrap up a little bit early. Thanks everyone so much for your participation, particularly a huge shout out and thanks to both Assistant Attorney General Kristen Clarke and her team, Commissioner Slaughter's team, and of course her, and of course to everyone at NTIA who worked hard behind the scenes to make this happen. Thanks to all of our panelists and to Lauren for participating. Thank you, David, Bert, Lydia, Michelle, and Aaron. Thank you so much. And thanks to everyone who both tuned in and, of course, actively participated by sending in some questions or participating live. We are looking forward to the sessions tomorrow and on Thursday, and the recordings and transcripts will be posted as soon as we possibly can. So with that, I'll give you 12 minutes of your day back, and thank you so much.